Afternoon. It's Friday, February 5th. The legislators are on their way back to their communities, and this is the weekly update. House Bill 1062, an act to permit an order changing the name of a minor child without publication. That's down on the governor's desk through both houses. 1063, that's revising the notice requirement when the primary custodian moves, and they have to give notice or not. When there's a protection order in place, this bill says they must if there's an existing visitation order. That's through the House, through Senate Judiciary. That'll be taken up on the Senate floor on Monday. The severed mineral bill, which is 1058, that's through the House. It was over, went through the Senate Judiciary, went down to the floor, and they made a minor amendment. They inserted, on page 2, if you're following it, they inserted the phrase, within the last 23 years. It's a very minor amendment, but nevertheless, under the rules, that amended bill now is through the Senate, but they'll have to send it back for the House to concur with that amendment. If the House doesn't like to concur, then they'll appoint a conference committee. I suspect they will concur. 1059, that's the revision on all our garnishment bills. That's been through the House, and it's awaiting hearing in Senate Judiciary. My best guess, maybe next Thursday or the following Tuesday. Our nonprofit bill. We're still negotiating with the governor's office. They've sent us a 15-page draft of what they would like to see the bill distilled down to from our 175 pages. We have Amy Arndt and Bobby Thury and Pat Getzinger and I all reviewing their proposal, and we're going to see if we can reach some sort of an agreement. We'll communicate with the governor's office on Monday with whatever we think ought to go back in. We have a meeting set with the governor's office on Tuesday afternoon to see if we can resolve those issues, and we intend to take the bill up Wednesday morning in House Judiciary. I want to do it that way because I'll have all these people, my experts and your experts, in town anyway for the meeting on Tuesday. Thus, we want to have the committee have the benefit of the testimony of those experts. Another bill that the Bar Commission authorized us to support was Senate Bill 54, and that is the work product from the summer study on elder abuse and what needs to be done for protection. Of interest in that bill, particular interest to us, is Section 38, where the legislature is charging the state bar with the responsibility of preparing training materials for everybody who is going to act as a guardian or conservator. We'll prepare materials and probably do a video, put it on our website, and then the people can choose which way they want to do it, fill out a certificate, file with the judge, and so we're supporting that bill, and it's moving right along. House Bill 1183, there's some concern from the Family Law Committee because it expands the jurisdiction of magistrate court to try and determine actions for protection orders or restraining orders pursuant to Title 22, which is criminal, and of course we see no problem with that. But it also talks about Title 2510. There's some concern about magistrate judges impacting protection order situations where children are involved. So we're waiting to see. There was an amendment today in committee. I don't know if that amendment satisfies the Family Law Committee's concerns or not, but we're watching it and we're working on it. House Bill 1180, that would limit conservancy easements to 100 years, and the State Bar has always opposed that concept, that bill, because we understand for estate planning purposes and for income tax purposes, all easements must be perpetual. Your bar commission have authorized us to oppose that. House Bill 1128 would require the judge in a divorce situation and custody situation that they must consider the child's preference. Family Law Committee thinks that that's a horrible idea. It's permissive right now, and your bar commissioners have taken that advice, authorized us to oppose 1128. Also of interest, and I don't have the, I think it's 1237. I think that's the correct number. A bill's been introduced to adopt the uniform law on powers of attorneys. Typically, the State Bar has always supported uniform laws. I haven't gotten that out because it was just filed yesterday, so I'm waiting for instructions from the bar commissioners on that one. Also of interest, and it's about Senate bill, and I'm going to say 155, 160, right in there someplace. And that is the Peter Falk bill. If you may remember, there was a lot of controversy years ago before Mr. Falk died that the second wife cut off all contact as Peter was slipping mentally. I think he had Alzheimer's. In any event, the new wife cut off the children from any contact with their father. There are many states that are taking this up that says a guardian should not be able to do that. I took a look at the bill and as a draft, and it simply said, it was all comprehensive, that said that a guardian could not forbid anybody to visit their friend, relative, or whatever without a court order. I suggested that they narrow that down to at least parents, children, and siblings, arguing or suggesting that you could have individuals who are trying to take financial advantage of the protected person, and to delay by the virtue of having to go to court was not a good idea. If it happens to be the parents or children, then perhaps there was some merit in that. I did not say that the State Bar would support it in that amended form, but I said, I can assure you that your bill will be in trouble if you don't narrow it down to those immediate relatives, and that the guardian can protect the protected person from the rest of the world. Still percolating on things like teacher pay and the 1/2 cent sales tax, Medicaid expansion, lots of stuff going on talking about all those things. We don't have a dog in the fight, but we do watch it. You have a great weekend.